Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hello and welcome to Inheritance Solutions for a Diverse Community with Richard Hall, founder of Bottom Line Lawyers. Richard combines extensive legal and real estate experience to help individuals and families prepare for the future and protect their assets. Today's episode is Wills versus Trusts, the ultimate showdown in estate planning. Richard, welcome back. Great to see you.
Thanks, Kevin. Good to see you again.
So why might someone opt for a will over a trust or vice versa? Are there specific circumstances where one is more beneficial?
Yes, there are. The decision between a will and a trust often really depends on several key factors. And a will might be a preferred choice for individuals with relatively simple estates, straightforward family situations, and modest assets. Wills are generally less expensive to create and require minimal ongoing maintenance. They're particularly suitable for young families primarily concerned with guardian designation for minor children. Trusts, on the other hand, provide many other benefits, including elimination of capital gains tax on assets that are held in that trust at the time of your passing. Business owners might prefer trusts for their ability to ensure business continuity without interruption. And the privacy aspect of trust becomes especially important for public figures or those concerned about potential family conflicts. Trust structures can also offer sophisticated tax planning opportunities that aren't available through wills alone. This includes generations skipping tax planning, charitable giving strategies, methods of reducing state tax liability. However, these advantages must be weighed against their higher initial setup costs and ongoing maintenance requirements. The choice might also be influenced by state-specific laws regarding probate processes and estate taxes. For instance, anybody who has a will, it must be probated in the state of California. And a probate in California can be expensive. There are statutory fees for probate, and they can take a period of time. During the pandemic, some probates were running 3 years to complete. Now, the average time is somewhere between 18 and 24 months. States with lengthy or expensive procedures often make trusts more expensive, and that's certainly true in California. So I'd say ultimately it's going to depend on the facts of your own circumstance, but my bias is strongly in favor of a trust because it gives you far more flexibility.
Can a living trust help expedite the transfer of assets and avoid delays that may come with the probate process?
Yeah, living trust can significantly expedite asset transfer through several mechanisms that bypass traditional probate processes. When properly structured and funded, a living trust enables immediate access or almost immediate access to assets for beneficiaries upon the grantor's death without court intervention or delay. This efficiency stems from the trust's ability to maintain continuous ownership of assets even after the grantor's death. Since trust assets are technically owned by the trust rather than by the individual, no ownership transfer process is required through probate court. This can reduce the time for beneficiaries to receive their inheritance from months or years to potentially just weeks. The efficiency depends heavily on proper trust funding and maintenance during the grantor's lifetime, though. And assets must be properly titled in the trust name. So for instance, real estate actually has to have a grant deed putting it into the trust, at least in California. Without that, it isn't technically part of the trust, would still be subject to capital gains tax, et cetera. There is a workaround for that, but again, it adds time and expense to the process. Assets must be properly titled. New acquisitions must be consistently added to the trust. Failure to maintain the property trust funding can result in assets falling outside the trust and requiring probate anyway. People get a little confused sometimes by the phrase trust funding. It just means that the assets are titled to the trust. The expedited transfer process also provides practical benefits during incapacity. Unlike a will, which only takes effect upon death, a living trust can provide seamless asset management if the grantor becomes unable to manage the affairs either temporarily or permanently. The successor trustee can step in immediately without court intervention.
All right. So when it comes to distributing assets to heirs, can a trust provide more control over how that's done? And if so, how does that work?
Yeah, trust can have actually fairly granular control over what happens with assets. You can specify things. One example that comes up is you have a family member, a beneficiary who you love, but has currently a substance abuse problem. We can put provisions in there that they either cannot get it until they demonstrate that they are free of that substance, or put it into what we call an SNT, special needs trust, within your trust, so that they get allocated certain amounts by the trustee of the trust. So there's significantly more sophisticated control over asset distribution compared to a will. Trust can establish detailed distribution schedules based on age milestones, allowing assets to be released gradually as beneficiaries mature. For example, a trust might distribute 25% at age 25, 50% at age 30, et cetera. The staged approach helps protect beneficiaries from poor financial decisions in their younger years while providing them time to develop financial maturity. You may get a chuckle out of this, but typically we end up putting a longer time on the male beneficiaries than on the female beneficiaries, because experience tells us that the female beneficiaries are often more financially savvy than their counterparts. They're not.
Whoa. No, that checks out.
They're not going out to buy a Lamborghini or something like that. Beyond age-based distributions, trusts can incorporate incentive provisions that align with their values. Might include releasing funds upon completion of higher education. You finish that degree, you get your money. Maintaining employment or achieving sobriety, as I implied before. Trust can also protect beneficiaries from creditors. We put a spend-through clause in virtually every trust, very substantial clause, which says the creditors can't come and get that money that's coming to you. Also means that the beneficiary can't go and hypothecate or borrow against their proposed inheritance. So it really protects both the trustor and the beneficiaries. For beneficiaries with special needs, trust can be structured to provide supplemental support without jeopardizing eligibility for government benefits, what we call a public benefits trust. The level of precision in distribution planning isn't possible with a simple will. Trustee can be given discretionary authority to make distributions based on the beneficiary's specific circumstances and needs. We can even create an irrevocable trust that the beneficiary never has control over, so there is no interference with public benefits administration. The trust can establish conditions for family business succession, ensuring smooth periods of transition. It can provide for requirements for beneficiaries to gain relevant experience before assuming control of a business.
And is there more flexibility in a trust than a will as far as making changes or updates after it's been established, or is it pretty equal?
Yeah, it's an interesting question, Kevin, because the flexibility of trust versus wills involves nuanced considerations depending on the type of trust and the specific circumstances. Revocable living trusts offer significant flexibility to the grantor during grantor's lifetime, including complete revocation. So if it's a revocable trust at any point in time, the trustor, the trust maker, can just say, I've changed my mind. I don't want to do that. They revoke the entire trust and do something different. But can allow for modifications to beneficiaries, distribution terms, trustee appointments as circumstances change. This flexibility varies significantly between revocable and irrevocable trusts. While revocable trust can be amended or revoked entirely, irrevocable trust, hence the name, trusts generally offer limited modification options once established. Modern trust law has evolved to provide some flexibility, even in irrevocable trust, but through trust protector provisions, decanting powers, and trust modification agreements. By the way, you will hear it called irrevocable and irrevocable trust as well. The ability to make changes must be balanced against other objectives such as tax benefits and asset protection. They require irrevocability. Some states have adopted modern trust laws that provide mechanisms for modifying otherwise irrevocable trusts. For instance, in California, you do have a thing called decanting provisions.
Are there any situations where someone might choose to use both a will and a trust in their estate plan?
Absolutely. In fact, I commonly do that in my practice. Employing both a will and a trust in the estate plan is often the most comprehensive approach, as each instrument serves distinct purposes that can complement each other effectively. For instance, we do what's called a pour-over will. And the pour-over will says that anything you own at the time of your passing pours over into your trust. And therefore, even if you haven't moved an asset, non-real estate asset, into your trust, it is moved in by virtue of your will. Real estate, however, as I mentioned, must be deeded into the trust. And that is an important distinction. The type of will directs any probate assets to pour over into the existing trust, ensuring that they all fall into the trust distribution scheme. This gives you predictability and certainty about what will happen, even if you forget something along the way. The will remains essential for certain functions that trust cannot fulfill. For example, only a will can name the guardians for minor children, while a trust can manage financial assets for their benefit. The actual appointment of physical guardians must be done through a will. This makes having both documents crucial for parents of minor children. Business succession planning often benefits from using both instruments. While the trust can provide detailed management and distribution provisions for business interests, the will can address any business assets not yet transferred to the trust and provide additional instructions. Complex family situations, blended families, children from multiple marriages, non-traditional families, all can benefit from having both a will and a trust. Healthcare decisions and end-of-life decisions may involve both documents, with the will confirming the burial wishes and personal representative appointments, while the trust manages financial aspects of long-term care and disability planning.
Are there certain types of assets that are better managed through a trust than a will?
Yeah, different types of assets benefit from estate planning instruments that are different. Certain assets being particularly well suited for trust management rather than will distribution. Understanding these distinctions is crucial for effective estate planning. As I've mentioned a couple of times, real estate, especially properties in multiple states, strongly benefits from trust ownership. Trust-held real estate avoids ancillary probate proceedings in different states, amplifies management during incapacity, and enables smooth transition of control upon death. This is particularly important for income-producing properties where continuous management is essential. Business interests almost always benefit from trust management rather than will distribution. Trust can provide uninterrupted business operation during transition periods, incorporate detailed succession plans, and maintain confidentiality of business operations. They can also include provisions for professional management during transition periods and specific criteria for successor leadership, perhaps even training for those new potential leaders. Investment portfolios benefit from trust management through professional investment provisions, consolidated management of diverse assets, and the ability to implement sophisticated tax planning strategies. Trust can provide continuous investment management during incapacity and smooth transition upon death. Intellectual property rights, including patents, copyrights, trademarks, are often better managed through trust. Trust can provide ongoing management of these assets, including licensing agreements and royalty distributions, while maintaining continuity of protection and exploitation of these rights. And as we mentioned, they're much easier to transfer because the trust retains the ownership, and so they can be distributed more readily if they're owned by the trust. And then digital assets and cryptocurrency holdings benefit from trust management due to the need for secure access protocols and specialized management expertise. Trust can include detailed provisions for digital asset management. One thing to do is remember when you create your estate plan to make provisions for the termination of certain electronic benefits that you've got. Some accounts can only be terminated by the creator of that account and not by any successor under any law. Something else to think about when you're creating your estate plan.
And finally, for someone who's just starting their estate planning journey, do you have any advice for them as far as how they can go about choosing between a will and a trust?
For individuals beginning their estate planning journey, really the choice between a will and a trust should start with an assessment of what their current situation, long-term objectives, and assets are. A decision process should be methodical and consider a variety of factors. Begin by conducting comprehensive inventory of assets, including their nature, value, complexity of management. Consider not just current assets, but also anticipated future acquisitions or inheritance. This inventory helps determine whether the additional costs and complexity of the trust are justified. Evaluate family dynamics and beneficiary situations. Consider factors such as ages, financial responsibility or irresponsibility, as the case may be, special needs, and potential family conflicts. And consider privacy concerns and comfort with the probate process. If privacy is a significant concern, or if avoiding probate is important due to state-specific processes, this might favor trust creation. And in particular, in terms of privacy, if a case goes to probate it's public knowledge. Everybody's going to know it. People sit in the courtroom, and anybody who looks at the file is going to know it. So trust is by far more private. They've been used by wealthy folks for 500 years to shield assets. Examine your comfort with ongoing administrative requirements. Trusts require more active management during the lifetime, including retitling assets and maintaining proper documentation. And then finally, recognize that it isn't necessarily a permanent decision. Estate plans can evolve over a period of time as your circumstances evolve.
All right. Well, thanks for listening to Inheritance Solutions for a Diverse Community with Richard Hall. For more information, you can find Richard Hall on social media, and you can also visit bottomlinelawyers.com. And please like and subscribe to our channel and leave us a review. Richard, always great to hear from you. Thanks so much for being here.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.